Hi, sir. Jayden Dumont.
Jayden Dumont.
I see him in the room.
So if I may, Judge?
Yes, sir.
Okay, so here's what happened in this case. And I know the state's going to request a dangerousness hearing, but I don't think it's really necessary under these circumstances. So if you look at these multiple violations which occurred, one of them was due to a battery malfunction. The battery pack hadn't been sent up from Miami, but he had been to the location where he was being treated. That's the one which was not his fault. The others were, as you want to know, is there's a GPS monitor on your ankle, which you have to wear. And there's a weird device, a GPS device you have to carry with you also. He never left the facility in any of these violations. What happened was he left the GPS handheld device in his room. It took him down for his medication. He got his medication administered. The alarm went off. Should he have taken it with him? Yes, he should have.
It was a number of times though, wasn't it?
Yeah, he just didn't take it with him. I can't explain why he was that negligent in not taking it with him. But he never left the facility. Now, this gentleman's name is
Robbins.
And Mr. Roberts, what did you want to say?
The same thing that you're saying. He never left the facility. He was always on site. And I also spoke to Evolution. And I also spoke to him as far as him returning and then say that they were willing, they had no behavior issues with him. They weren't aware of his monitor issues. So that was something between Mr. Dumont and his probation officer, but outside of his behavior, they said he was.
And I've read him the riot act, Judge, and now he's been sitting in jail for this time. He's up so much better. I mean, I can tell you, just having spoken to him, he's made a tremendous amount of. Now, the state is welcome to ask for a dangerousness hearing, but there's nothing that's happened between the time of his plea and his his remanding to the facility. Evolutions, yes.
Ms. Lubin,
And now,
if he is admitting to the violations, can't he resolve?
Have to set a danger hearing where the state can present evidence. I'm not stipulating he's not a danger. Either he's unable to abide by the rules or he just doesn't care to.
Judge,
So I'm asking for a danger hearing. I'm not stipulating he is not a danger. If you want to reset it to have Mr. O'Connor review it, I reviewed the violation, I reviewed the report that the officer put in, the facts and circumstances. Either he doesn't get it or he's just choosing not to abide by it, but he signed the reports. At one point it said the officer went in and he just stared at them with a blank face. So I don't know what's going on, but either it's not an appropriate level of care or he just doesn't care to abide by the rules, and I am not stipulating that he is not a danger.
I don't think that happened on this thing, but I've been trying really hard to keep a monitor on my pants. The thing is that it's been kind of like sagging them, so I've been on. I asked my parents to get me a bag to put it in, and I'm gonna be a lot better with carrying my boards. I know how the whole program works now. The reason that I left it in my post so many times was because my group teacher told me to leave it and go back to the room. So I'll go back to the room after and then acknowledge the list.
and we're ready to admit, Judge, but I understand the state's position, but there's no basis for a finding of dangerousness under these circumstances. Just negligence, and honestly, he did something he shouldn't have done, which was maybe youthful stupidity. I don't think, but he never left the facility, Judge.
How are you finding evolutions?
I mean, the treatment there is great. It's been helping me learn how to cope a lot better with like my issues with anxiety and medicine. I'm really compliant. So it's medicine and it's been very helpful. I'm glad that I get to see my family occasionally and stuff like that. It's really
Mr. O'Connor will be back on December 1st. He may feel differently than me, but this is my position. I'm standing on my case and I'm not comfortable waiving that requirement.
I understand that, Judge. If we do set it though, and he sits in jail for this period of time, I don't want to compensate. He's doing so well, so
Okay,
I'm ready to admit.
I'm not able to accept the admission without first having a danger hearing. I'm just,
He can admit and you can set it the matter for the danger hearing.
You know, Judge.
I couldn't release him until it's resolved, right?
Correct.
Yeah, I don't want him to lose the bed. Can you make that statement to the court, please? If you would.
No, I'm just stating the fact that he has been compliant, has been cooperating with Evolutions and doing all that they've requested of him. Again, and I'm expressing to you as far as the negligence, I didn't understand either. I did speak to the probation officer, who did say that she did speak to him, and that there was a form that he did sign, so he was aware as far as that was concerned. But he has been progressing as far as his treatment was concerned, so he's been complying in that regard.
Okay. Mr. O'Connor is back on December 1st.
Yes.
That's a really, really heavy day. We have 151 cases that day.
It would be an admission, Judge, at that time, if the court's not gonna find dangerousness, and I would submit that based on the record we have here, which is complete. I don't see how, of course, it's always up to the court, what's discretion, but I don't see any basis objective or dangerousness.
Procedurally, I think they have to have their danger hearing. I'm sorry, sir, what? Okay, I'm gonna set a danger hearing for December 1st. 8:15.
Okay.
Judge, and if the court does not find dangerousness, we'd be ready to admit that,
Okay.
and hopefully he.
Well, he has to plead before the hearing. So you could do that today if you want.
Judge, we'll admit today, we don't have any concern about the facts. The facts are as is stated, that I don't think probation has the dispute, is that correct?
He just pleads and then the state presents evidence at the danger hearing,
Okay,
whether the officer can come in, I mean, that's.
do you want to fill out a plea form with
Sure.
him? And Robbins, in the event that I find he is not a danger, can you ask Evolutions to hold a bed for him until December
I spoke to
1st?
Brad yesterday, he said that he'd be welcome, but I definitely doesn't.
I just, to your point, if I make that finding, I just don't want him to lose his bed.
Sure, I'll also contact him as far as his belongings, because he does
Okay.
have his belongings there.
Okay,
Judge, I don't know if the court would be amenable to doing this, but you could remand him back there, he's on house arrest. Pending the dangerousness hearing, we'll admit today, so.
I mean, I don't think I can release him from custody. Being at Evolutions on a level one, on a GPS monitor is not, custody.
If Your Honor were to find, for instance, that the violation was a technical violation, I think you might be able to do that. Now, if you did make that finding, that would not prevent you, if there was a finding of dangerousness, by having it remanded back to the Broward County Jail. It's just such a, I mean, procedurally, I understand the need for the dangerousness. I got it. What I'm saying, there are remedies that the court can engage in under these circumstances. Put him back there on a house arrest status, and then bring him back to court that day.
I would like to accommodate your request, but I don't, that's not my understanding of the statute. So I'm going to reset for December 1st, and we can have the hearing on that day.
Yes, sir. All right, I'll get a form and we can
Thank you.
thanks.
Yes, sir.
Just like page 30 and 32.
Uh-oh, Judge. Log out, Judge, just log out.
It's ruined.